We are meeting virtually today via WebEx due to weather events around the state. So thank you all for joining us here today and for your testimony. So we have a busy agenda today. We're going to start and open the hearing on Senate Bill 138, requiring search warrants to be issued only on the statement of facts sufficient to show probable cause made by a law enforcement officer. And with that, then, a brief from the reviser.
Thank you, Madam Chair. Senate Bill 138 amends KSA 222502. That's the statute about issuance of search warrants. Current law there, you'll see in subsection A, provides that a search warrant shall be issued only upon the oral or written statement of any person under oath or affirmation that states facts sufficient to show probable cause. And this bill would amend that to allow the search warrants to be issued only on the oral or written statement of a law enforcement officer on facts sufficient to show probable cause. And I can take questions.
Thank you. And committee, I want to remind you that your the committee testimony and those following along online is online, so you should be able to access those. And I want to make sure that we have everyone online. I'm looking, and it looks like we have, and we have Senator Argabright in the committee meeting room. So thanks for being there, Senator. Do we have any questions for the reviser? I'm looking for hands up. I don't see any. So with that, then we'll invite Todd Thompson, County Attorney, on behalf of the Kansas County District Attorney Association. Please, I think I said that wrong. It's the Kansas County and District Attorney Association. So please introduce yourself and welcome to committee. We can't hear you, so you're probably muted, and I don't yet see that he has joined the meeting. So we're going to wait to give him an opportunity to join. And if the committee assistant can maybe send him an email. Thank you also, Ms. Moore, for being in the committee meeting room there. Appreciate it. So we'll go ahead and hear from Aaron Breitenbach, Deputy District Attorney, on behalf of Mark Bennett, District Attorney, 18th Judicial District, and on behalf of the Kansas County and District Attorneys Association. Please introduce yourself and welcome to committee.
Yes, thank you, Madam Chair. I'm Aaron Breitenbach from the District Attorney's Office here in Central County. I'm speaking on behalf of our office and KCDA on this bill. We proposed this bill. It's relatively straightforward. As stated in my written testimony, we've had just a recent situation that's come to our attention, both for us and then Todd Thompson up in Leavenworth, of search warrants being approved when the affiant, the person seeking the warrant, is a non-law enforcement officer. Now, to date, it's only been one particular criminal defense attorney. So, I guess there could be feelings about whether that's an issue or not. But the concern, the crack, so to speak, that this revealed is that theoretically, when you say any person could provide the probable cause statement in support of and seeking a warrant, that creates a lot of concern about how the search warrant powers of the state could be used or misused for a variety of reasons. Currently, how the process works, for those that don't know, is that generally a law enforcement officer, through the course of their investigation, provides an affidavit setting forth what they believe is probable cause. In some jurisdictions, in most jurisdictions, that is ran by a local prosecutor who also reviews it for that same purpose. And then the law enforcement officer presents that to the judge, whether it's during the day, after hours, whenever it might be. If the judge believes there is probable cause, they approve that application, or approve that warrant. And then that warrant is given back to that officer for either that officer or fellow members of their agency to execute. When it's left to any person to provide that affidavit, one could imagine a situation, for example, where, say, a criminal defendant is charged in a case. Well, there's already a probable cause determination that a crime has occurred, right? So they could just add, assertions of what evidence may or may not exist in, say, a complaining witness's house, uh, statements about the law enforcement officer investigating them, any number of people. And as long as there is some factual nexus between the crime that they're charged with and where they say this other evidence may be, a judge is put in a difficult situation, right? Where they're not in a position to evaluate the full credibility of that person's statement. When a law enforcement officer writes an affidavit, their licensure is on the line, their career is on the line. If they misspeak, if they put a falsehood in an application, that can be a basis for their career to end potentially. We had testimony yesterday on a bill where it was talked about how doctors have licensure, and so their statements are given greater credibility. Well, that's very true of law enforcement. And so there's that kind of additional level of accountability to make sure the information provided to the court tells the whole story and is true. Those type of protections aren't there when any person becomes the affiant. So we are asking to modify the statute to fit practice, and not just recent practice, but literally hundreds of years of jurisprudence in America, where law enforcement are exercising their limited ability to get search warrants under judicial review. And so we believe it's a relatively simple fix. It closes a loophole and it protects the community from abuses of the search warrant power. Because the last thing we want to see, and we've sadly seen examples of maybe a warrant that shouldn't have been granted here or there, one could only imagine how those concerns could magnify if those with ill will began to try to use those powers for nefarious reasons. And so that's why we seek these amendments. I haven't been able online to see if there are opponents or what their concerns are. So if through the questions you might give me an opportunity to address those, I'd be glad to do so. But that's the basis for our bill, and I appreciate the opportunity to be heard.
Thank you. And we'll go ahead and save questions till after we hear from all the proponents. I see that Todd Thompson is on WebEx now, so we'll circle back to him. And he's county attorney, and he's here on behalf of the Kansas County and District Attorneys Association. So please introduce yourself and welcome to committee.
Thank you, Chairwoman. Appreciate it. I am Todd Thompson. I am the Leavenworth County Attorney, also the chair of the Kansas County and District Attorneys Association Legislative Committee. I probably let the better person of the two of us speak because Aaron was very articulate in the concerns and needs. We are the two counties that have been affected, at least affected the most by this, what I think is just a loophole that it needs to be fixed, but it's a very important loophole. One of the most fundamental rights any of us have in the United States that we are happy to have and proud to have is our right to privacy. This opens up a door for anyone, as the statute says, to file for a search warrant. I understand that there are processes at hand that can limit whether it gets granted, but just as Mr. Breinbach said, the people that generally will or always do this is law enforcement. Law enforcement has, they're going off of background, they're going off of information, they're going off of research, and they're putting their name and their title on the line when they do this. The average citizen won't have that occur when they apply for something. And it does put the judge in quite a bind on whether to approve this or not. But it also, the statute has law enforcement serving these search warrants. And in serving these search warrants, especially if they're not really what they're prudent to be approved yet have to be, it puts law enforcement in a difficult and maybe even a dangerous situation. We have to think that a lot of times when law enforcement is looking to do a search warrant, they look to do these search warrants with a lot of things in mind. What's the best timing to do this? What's the best avenue? And whether it's even necessary. And that those parameters don't exists for an average citizen who could have some potential issue, but they want to have searched or request to have searched. And with that, I have concern that the fact that this has started, that this will be something we'll see a lot more of, and obviously something that is a necessary fix and an easy fix at that. And so, similar to Mr. Breinbach, I stand for any questions after all testimony.
Thank you. Do we have any persons wishing to testify as proponents on the bill, either in the committee meeting room or on WebEx? I'm not seeing any, so we'll go ahead and open it up for any questions, and make sure that if I don't see your hand, you let me know you have a question. I'm not seeing any. So I have just two, just about the process. How long has the statute been that any person can file an affidavit for a search warrant? How long has that been the law?
To my knowledge, I think that's
And
how it was
please
originally.
identify yourself again. Thank you.
Thank you. I'm sorry, Madam Chair. This is Aaron Breitenbach from the Central County District Attorney's Office. To my knowledge, that language has been in there since the search. So the search warrant statute, I think, was passed originally, I want to say in 1970, when much of the criminal code was codified. And I believe that language, that term, has been there throughout. I can't speak exactly to why it was in there. My guess is, and this is my guess, is that there might have been some confusion, not confusion, but there might have been some belief at the time that when it says any person, well, any person can provide information to law enforcement, which then forms the basis for their request of an application. How this language has been interpreted, though, at least by courts in our two counties, Leavenworth and ours, is that any person refers to the affiant themselves, right? So by making it clear that, and in reading the statute, I can understand that interpretation. So what we're doing here is saying, again, any person can report a crime to law enforcement. Any person statements can be included in the affidavit, but the person who swears to the affidavit and presents it to the judge, that person needs to be commissioned law enforcement. So we're really, I think, just clarifying what the intent was all along, because obviously the search warrant process refers to state action, right? And it codifies, concepts that go back to our founding. And so that's what we're trying to do here.
Thanks, and maybe research or the revisor can answer the question. If you take a look at another question and agree that we need to be truthful in our interactions with the court, are there criminal penalties in place if a person files an affidavit for a search warrant and is later found out to be it wasn't factually the case? Is that perjury? Is that fraud? What is that? And maybe that's a
So this
question
is
for the revisor. I'm not sure.
if
Go
you'd
ahead,
like,
Aaron.
Madam Chair, this is Aaron Breitenbach from Central County. It wouldn't be perjury because, I mean, it could be. It kind of depends how the oath is done.
Right.
But
Well,
it could be
you've sworn an oath, so
right, whether it's done in court or not, and the oath that they swear, the wording of it can sometimes make a difference on perjury. But it could be, there is a statute against basically inducing, committing a fraud on the court. So there could be criminal liability there. There could be indirect contempt proceedings, perhaps. So there could be remedies, but of course, those are after the harm's been done, right? After someone's home door's been kicked in, or their phone's been searched, or their bank records have been examined, or whatever. It, you know, the concept behind some of the protections for our search warrant powers are to prevent the abuse from happening in the first place, because we recognize that that intrusion into someone's privacy, as Todd Thompson spoke to, you know, our home, our premises, our body. I mean, our whole country is based on the freedom of protecting those things. And so, just relying on some recrimination afterwards doesn't fully heal the harm potentially caused. And so that's why we would rather just fix it on the front end, and that just takes care of it. I will say, for law enforcement who, if let's say they're found to have misstated something in an affidavit, either intentionally or unintentionally, that can have effects on their career. It can obviously have effects on the case for which that evidence might have been obtained or used. There are a number of circumstances that create a natural disincentive for the affiant themselves, you know, to make a misstatement or make an error, because they're not going to benefit from it. You know, so that's how it works currently.
Thank you. Appreciate that. Do we have any other questions? Not seeing any. Do we have any persons in the committee meeting room or on WebEx wishing to testify neutral or opponent on the bill? Not seeing any, then want to thank our conferees. Appreciate your time and your testimony, and we will close the hearing on Senate Bill 138.
Thank you, Sarah.
You bet. Thank you for appearing. Appreciate it.
Thank you.
Next, we will open the hearing on Senate Bill 156, creating the crime of unlawful use of a laser pointer and providing criminal penalties therefor, and a brief from the reviser.
Thank you, Madam Chair. Senate Bill 156 enacts a new section of law. It would create the crime of unlawful use of a laser pointer. It would define unlawful use of a laser pointer as knowingly directing light from a laser pointer at a law enforcement officer while that officer is engaged in their duties, or an aircraft in flight, or the flight path of an aircraft. The penalty for the law enforcement provision would be a Class A person misdemeanor, and the penalty for the aircraft position provision would be a severity level 9 person felony. The provisions of the new section related to aircraft do not apply to any person authorized by an aircraft manufacturer or the FAA to conduct research and development or flight test operations while they're conducting that business. It also doesn't apply to members or elements of the Department of Defense or the Department of Homeland Security acting in an official capacity, or an individual using a laser emergency signaling device to send an emergency distress signal. As used in the section, laser pointer is defined as a device that emits light amplified by the stimulated emission of radiation that is visible to the human eye. There's also a provision that says that a person who violates the provisions of this new section may also be prosecuted for assault or battery if their conduct meets the definition of those crimes. And I can take any questions.
Thank you. Committee, any questions? Not seeing any. So we will invite Sage Hill, President of the Kansas State Troopers Association, to testify. Please introduce yourself and welcome to committee.
Hey, good morning. Thank you so much for having us. My name is Sage Hill. I'm the president of the Kansas State Troopers Association. I've been a trooper with the Highway Patrol for about 17 years, and the last 5.5 of that, I've been a pilot in KHP's Air Support Unit. So I know you have the written testimony that we submitted. I think that's a decent snapshot of kind of our buy-in with this legislation. And I'd like to give you maybe some additional context by actually taking a step backwards on a couple of things. Can you all hear me okay, Madam Chair?
Yes, it was getting a little broken up there for a minute, but I think it's all right.
Okay. Let me know if there are any troubles, and I'll try to fix it. So one of the reasons that it's such a big deal, I believe, and our organization believes, for law enforcement overall in this state, is there are no criminal penalties at all for pointing a laser pointer at an officer in a traditional law enforcement role on the ground right now. And why that's concerning, and I've got some anecdotal firsthand experience with both ground-based operations and in the air. If people are interested during the Q&A portion of this, lasers are commonly associated with the aiming systems of modern firearms. So if you just put yourself in an officer's position of whether you're just on patrol out, driving around, whether that's as a trooper or a deputy or a city officer or a game warden or whatever, you look down and there's a laser glinting off of the equipment or ornaments on your uniform. That's a pretty precarious head state to be in. You don't know if that's attached to a gun. You don't know why someone's doing that. And if you're engaged in any kind of active enforcement function, handling a call or anything like that, you can see how it would quickly have the potential to escalate a situation. And as stated, absent any other crime observed by officers, that is not unlawful conduct in the state right now. Specific to airborne operations, it is technically illegal. There's a federal UCR that covers it. It is not by local authorities an arrestable offense. And again, taking a step back and just trying to give some additional context for why we think that's important to change is when we're out flying at night, whether that's us doing law enforcement operations or general aviation or commercial passenger carrying operations, our military partners that operate in and out of McConnell, as pilots and aircrew members, our eyes are adjusted almost entirely for total darkness. When we go to work or when we pre-flight the aircraft, we're doing it with red flashlights and a really dim hangar so that our eyes can adjust down. Conceptually, it's the same thing as you get up in the middle of the night and you flip a light on, and a normal 40 or 60 watt light bulb that you're used to seeing every day in your house is really uncomfortable and actually painful in the middle of the night when your eyes are conditioned for darkness. So we go out, we're flying around, and in this state of conditioning for darkness, and one of the most intense light sources on the planet, a laser beam, floods in the side of the aircraft, and it can be extremely disorienting for the crew. Equipment that relies on visual aids like cameras and stuff can be completely flooded out. And again, have some firsthand experience with it. It's a really hazardous situation for flight crews and for anybody on the ground that could be impacted by a crash. So again, I think the written testimony is a decent synopsis. I know you've got a lot of business to do today. Thank you so much for letting us speak to you, and I'd be happy to answer any questions or get started on any additional information gathering that you have for this.
Thank you. Appreciate it. And we're going to hear from all the proponent conferees, and then we're going to take questions. So next, we're going to invite Ed Klump, Legislative Liaison, on behalf of Kansas Association of Chiefs of Police, Kansas Sheriff's Association, and Kansas Peace Officers Association, to provide testimony. So please introduce yourself and welcome to committee.
Thank you, Madam Chair. Ed Klump, Kansas Association of Chiefs of Police, Kansas Sheriff's Association, Kansas Peace Officers Association. For the reasons the previous conferee spoke about, we're strongly in support of this bill. This is something that is a gap in our laws today to protect officers, and it's important not only for our airborne officers but our ground officers as well, as has been previously alluded to. So rather than go through all that again, I do want to point out in our testimony in the middle of the page where the bullets are, is information from an International Association of Chiefs of Police document, a training bulletin that was issued on this. And it summarizes what the physical effects and hazards can be from these lasers on officers. And that's why this is so important. It can actually be career ending. Fortunately, we haven't had many of those happen, but there has been a couple across the country. We're being confronted with these in crowd control situations. During the disturbances 4 or 5 years ago, it became common practice for demonstrators to use lasers and shine them into the eyes of officers trying to control the crowds. And actually got to the point where the recommended tactical gear now includes goggles or glasses that protect the eyes from laser beams. So it's an actual threat. It's a huge concern. And the federal law that covers this issue only covers aircraft. It's actually an aircraft statute. If you're interested in that, I'll put the U.S. code number on my testimony there if you want to look at it. But it does not cover these things on the ground, as the previous speaker talked about. So this is very important to all of us, and something we'd appreciate the committee moving forward. And I'll stand for questions.
Thank you. And I know, Ed, you've had a busy morning this morning. You've appeared in Senate committees at 8:30, 9:30, and now 10:30 today. So
This is number
thanks.
4.
Oh, this is number 4. So I missed
Yeah.
one in there. So you must have been in a House committee as well. Well, thank you. Next, we're going to hear from Tuck Duncan, Executive Director, Kansas Public Transit Association. Please introduce yourself and welcome to committee.
Well, thank you, Madam Chair. It's been a long time since I've been in front of the Judiciary Committee in the Senate, usually on liquor matters. But I have been running the Kansas Public Transit Association for the last 17 years and dealing with a variety. And when this came up, I talked with my board, and the fact is bus drivers are just as susceptible to the potential of being blinded by lasers. Members of this committee from Wichita, Topeka, Johnson County all have fixed route services. We've got services in other parts of the state as well. There's 140 different transit systems in the state of Kansas. And so many times they're driving, and they like a pilot who's got passengers in the back of the plane. Bus drivers also have any number of passengers, and so the use of such a laser against them, which could cause them to swerve off the road or into some fixed object or an accident, would obviously be quite dangerous. So in looking at the bill, it seemed to us, and I've checked, there are other states that do have this same criminal liability when it's used against bus drivers, primarily in big cities, New York City, MTA, some others have had it for a number of years. So we're asking that you include transit operators as another segment of the population who would be subject to this protection. Now, the second part of my testimony, which the bill, as has been indicated, also talks about penalties for this being an assault. The last couple of years, we've been over on the House side, and I've been working with Representative Sanders out of Salina. We've had some bills over there that have been talking about assault against individuals. We specifically had one for bus drivers. The House passed one for health professionals a few years ago. As a result of COVID, it seems that the population is a little less tolerant than it used to be with regard to various activities. And it's not uncommon for a transit operator or a referee at a game. I just saw one on the TV the other day. Some poor guy got beat up at a hockey game. And that's the interest that Representative Sanders had, was he's got referees who are being accosted and assaulted, and doesn't seem to be that we have enough specificity in the law dealing with the types of activities which might create an assault. So when we had a bill in the House last couple of years, the objection was we were just merely adding another name or another occupation, and they didn't want a huge laundry list of occupations. We've already got this increased felony protection for law enforcement, and I've cited them in my testimony. Some healthcare professionals. We have it for school personnel, certain publicly employed attorneys like those who testified to you earlier today, and community corrections officers. So we've developed a potential amendment that would basically create an enhanced sentence for certain designated activities, whether it be throwing fecal matter at people, and you go, gee, does that really occur? Yes. Or spitting or other things that are obviously offensive and objectionable but are not really defined in our assault and battery laws. So that's the amendment. It's set out. My understanding was that Representative Sanders had talked with the revisor's office about taking my language and improving it somehow. And I'd be glad to talk with the committee even more. So one, we support the bill. We think bus operators who are all over the state driving people every day to and from work, medical appointments, shopping, and the like should not be subjected to the potential of lasers being used against them. And finally, we've created some language that would up the game, as it were, for people who are abusive while someone is simply trying to perform their job. And it seems to us that there should be some enhanced sentence, and since this bill seemed to be germane in that regard. And I'm be glad to answer any questions that you might have. So, and happy Lincoln's birthday. Do we still
Yes.
celebrate Lincoln's birthday? We did when I was a kid.
It's still his birthday, yes. And also, happy birthday to Senator Bowers. It's her birthday as well, if I'm correct about that.
Should we?
That
I'd be
is
glad
right.
to sing happy birthday to her if you want.
I know, right? So I'm not a very good singer, but we do certainly wish her a happy birthday today.
Thank you.
You're welcome. Are there any other proponents wishing to testify who are in the committee meeting room? I see Senator Clays is in the committee meeting room too. Thank you for joining us. And do we have any persons on WebEx wishing to testify as proponents? Not seeing any, then committee want to direct your attention to online proponent written testimony from Steve Hitchcock, Government Affairs, Kansas Agricultural Aviation Association. And with that, we'll open it up for any questions. I'm not seeing any questions.
Can I
have
ask
just,
you a question, Madam Chair?
well, we'll see. What is it?
I was curious when you might work this bill, since we're getting towards turnaround. Or if
Sure.
you will. I would ask you in your office, but I can't get over across the street today.
And I'm not in my office, but you know, we will be busily working bills. It's not our usual practice to work bills when we're not in a committee meeting room. So, and especially if there's an amendment coming, we like to have the amendments written and go through the process that way. So, want to give,
Thank you.
in fact, yep, you bet. I have a technical question, probably for the revisor, that was brought up by some of the testimony. When it says in the bill that the, because already, I mean, if you want to discuss just a minute what assault is and what battery is, already defined in law, if you could take a minute just to do that.
Sure, Madam Chair. Thank you. Let me pull that provision up so I can read it exactly here.
And
So
it pertains to my question of the bill says that you can be convicted, prosecuted, convicted, and punished for assault or battery. And I'm just wondering, do you have to, the bill doesn't say that you have to be separately show the elements of the crimes of assault and battery to be convicted of it. So I just want to be clear what those elements are, and if it's automatic, we should know what those are.
Sure. Thank you, Madam Chair. And I might just kind of elaborate on what that provision that's contained in this bill that you're talking about does really. Essentially, that's just saying that if your conduct were to rise to the level of assault or battery, there's nothing that says you have to be charged with this crime instead of assault or battery. And in some instances, you might be able to be charged with both. So it's just a statement that we sometimes add in there just to make clear that you know, nothing in here prohibits prosecution under those crimes if the prosecutor decided that that was more appropriate. But assault, the definition of assault, that's in KSA 215412. And it's knowingly placing another person in reasonable apprehension of immediate bodily harm. So that would be the elements that you're looking at there. And battery, there's a few different kinds of battery, but generally battery is knowingly or recklessly causing bodily harm to another person. You can see all the different elements there in KSA 2154-13. We do have some increased penalties when it comes to battery and assault against law enforcement officers. So for that particular provision, you know, those are the penalties that you'd want to be comparing. But
thank you. Do we have any information if that lasers, so when our pilots are operating the airplane, or when the bus drivers, is there medical evidence? I'm just curious. I would think that a laser in the eye would cause bodily harm. Does it medically damage your eye?
Yes, ma'am. This is Sage Hill, president of the Kansas State Troopers Association. We can get you additional information on that, but some of these lasers that are commercially available now on like Amazon and other major retailers, you can actually start fires with them. You know, if they're within close range to whatever you're pointing them at, they're incredibly bright, and they do cause. It's well demonstrated and proven that they do cause a lot of damage to the human eye.
And it wouldn't then, it sounds like, have to be just your eye, right? If it's just pointed at your body, that could cause harm, physical harm too.
That I can't speak specifically to, but I know for us and the ranges involved with aircraft and like Mr. Klump testified to, as far as the mass disturbances, you know, the riot type situations, the big concern is the eyesight.
Right. So they wear the protective goggles and.
Correct.
Okay. Well, thank you. Committee, we also do have neutral written only testimony from James Houston Bales, BIDS Legislative Committee, Kansas State Board of Indigence Defense Services. Do we have any other questions for our proponent conferees? I'm not seeing any. Do we have anyone in the committee meeting room or on WebEx wishing to testify as neutral or opponent to the bill? Not seeing any, then we'll close the hearing on Senate Bill 156, and thank you for your testimony. And we'll open the hearing on Senate Bill 186, requiring probable cause affidavits to be made available to law enforcement agencies prior to the execution of a warrant or summons. And with that, a brief from the reviser.
thank you, Madam Chair. Senate Bill 186 amends KSA 22-2302. That's the statute related to the issuance of arrest warrants. So still talking about warrants, just a different type of warrant here. Current law there provides that affidavits or sworn testimony in support of the probable cause requirement shall not be open to the public until that warrant or summons has been executed. This bill would provide that those affidavits and sworn testimony shall be made available to law enforcement agencies prior to the execution of the warrant or summons. And I can take any questions.
Thank you. Any questions? All right, then we will hear from Sheriff Jeff Easter, Kansas Sheriff Association Legislative Chair. Please introduce yourself and welcome to committee.
Well, good morning, Madam Chair and committee members. I'm Jeff Easter with the Sedgwick County Sheriff's Office. I represent the Kansas Sheriff's Association today. So what has occurred here is almost 4 years ago, OJA and the Supreme Court had decided that they wanted to move all of the district attorney's offices and law enforcement to a new system called Odyssey. There really wasn't any discussion with the other partners. It just happened. And then the process went into place of here's what you have access to. When it came to Sedgwick County and some of the larger counties, it wasn't doable. That's why it's been a process for 4 years. And so what currently occurs is when a district attorney or county attorney has submitted affidavits for warrants to be issued for arrest, for probable cause for arrest to the judges, and they're signed. We currently are in the same realm as the general public. That's what it's labeled in the grouping to be able to see that information. And so this is asking us to be taking out of that pool of the general public so that we can view these items in Odyssey. For some sheriff's offices, we've had to hire additional people to track down all of this information that we need to enter into NCIC, to enter into warrant sheets, and then to put that information out to law enforcement in the particular county. It takes a lot to do that when the information is readily available in the system, but we don't have access to it. So that's what our ask is today, ma'am.
Thank you. Do we have any other proponent conferees wishing to testify? Not seeing any. So committee, any questions? And I think through the 4-year process, Sheriff, I think one of the last counties to come online onto Odyssey was Johnson County, if I'm correct, right?
Yeah, they're not online yet because now they're going through the same process we are that we went through of trying to figure out. I mean, I don't know if Aaron's still on here, but DA's offices didn't even have access to their own sync cases. So that had to be worked through. There was numerous issues we had to work through to get access to information. And Johnson County now is starting that process.
So I think the issue I'm hearing you say is that if it's available to the public prior to, like the bill says, actually executing the warrant, then the person who the warrant or the business is directed at has knowledge ahead of time, and then it could be problems when law enforcement shows up to execute the warrant or the evidence is destroyed or things like that. Is that right?
Correct. I mean, the statute that talks about that they're not open to the general public, we're in favor of that. The problem is that OJA puts us in the same grouping as the general public. So this would, in essence, force them to put us in a different pool so we get access to it.
Okay, thank you.
Yeah, thank you.
Oh, no, go ahead.
Yeah, it's just permissions is basically what it is to give us access.
Thank you. Well, I don't see any other questions. Do we have, we do have neutral written only testimony from James Houston Bales, BIDS Legislative Committee, Kansas State Board of Indigenous Defense Services. Do we have any persons wishing to testify as neutral or opponent? I don't see any, so then we're going to close the hearing on Senate Bill 186. Committee, we do have some bills to work. They're not quite ready, though. I think we're waiting on some amendments to, I think, Senate Bill 70, maybe some amendments to some other bills too, but time is running short. So please make sure that you have those ready. When you have them ready, if you'd notify me, that would be helpful. And also, we don't want to have to work, you know, lots of bills on Monday. We will if we need to, but we kind of want to have opportunity to work what we need to. So it's snowing a little bit where I am. So I'm hoping that committee will meet in person tomorrow. So we'll plan on in person unless you see an email. We'll try to get that out tonight so that people can plan for tomorrow. So, and we are working Friday and Monday as well. So with that, thanks everyone for your travels, for your attention, for your time, and for your work. And with that, then the meeting is adjourned.